Thank you for the kind words. That's what you say in public. My name's Drew Coates. For the past 27 years, I've been an attorney with the Department of Public Welfare. I retired in June. I was hired back as a consultant in 2007, and they rehired me back as a consultant in 2008. But I think my tenure will probably, this will be my last year working as the attorney for the Department of Welfare. Dennis asked me to speak to you this evening regarding some elder law issues. And basically, if anyone is going to be in need of long-term care, a whole cottage industry has developed in the law of elder law attorneys. Elder law attorneys, to the best of my knowledge, were not in existence 35 years ago. These attorneys found this was an area of the law that you could make some good money and really assist a lot of people who are going through a trying time when one family member is going into a nursing home. So I think that the elder law attorneys act as attorneys. They also act as counselors. Basically, to become eligible for Medicaid long-term care in Pennsylvania, there's only a couple things you have to remember, and I'll try to make this as simple as possible. One, your resources and income have to be reduced to a certain amount. You don't have to write this stuff down. I just want to listen. It might be easier. If you have income of $1,911, which is approximately 30% of the federal poverty rate, you're entitled to have $2,000 worth of resources, and Pennsylvania also throws you a bonus. You can also have a $6,000 disregard. So basically you can keep $8,000 and still qualify for medical assistance long-term care. If your income is over $1,911, you can only have 2,400 hours of resources in order to be eligible. Basically, once you've spent down that money to those levels, you become eligible for medical assistance. Now, the problem is, and this is where the entire elder law field gets involved, it's what you do with the money before you get down to the resource level. There's also an income level. I mean, if your income is more than the cost of care in the nursing home, then you have to pay that cost of care to the nursing home if you have very excessive income. But basically, once you get down to that point, then we look back at what you did with your money before you reached the resource level. And that's why we look at transfers for fair market value. And if you're making transfers for fair market value and you've spent your money down to that level, you can become eligible for medical assistance. We also have a look-back period. If the look-back period used to be transfers into a trust, there was a 5-year look-back period. And if you just made outright transfers, it was a 3-year look-back period. The Deficit Reduction Act of 2005 changed that. Now the look-back period is 5 years for transfers, whether it's into a trust or an outright transfer. So if you made transfers 5 years before you went to a nursing home, when you filled out your application, it would say, if you made any transfers in the last 5 years, you write down no. And those transfers would not be penalized. So the 5-year look-back period is something you also have to keep in mind. You also have to be medically certified to get long-term care. Just because you want to go into a nursing home, unless you medically need that nursing home care or services in the community in a waiver program, you have to be medically certified. Now, in Philadelphia, the Philadelphia Corporation for the Aging does the certification, and I believe in the suburbs, your AAA, Area Agency on the Aging, they do the certification that you're in need of intermediate care at a long-term care facility. I mentioned the Deficit Reduction Act of 2005. They threw another obstacle you have to get by in order to qualify for medical assistance long-term care. That's called home equity. It used to be it didn't matter what the value of your home was because the home could always be excluded. The federal government decided in the Deficit Reduction Act of 2005, states would have the option of establishing a threshold amount for your home equity. Pennsylvania, it was anywhere between $500,000 and $750,000. Pennsylvania opted to take the $500,000 threshold. So if you have an equity interest in your property, in your home, that's over $500,000, you do not qualify for medical assistance long-term care unless you have a spouse in the house, unless you have a minor child in the house, unless you have a disabled child in the house. So if you've got a house worth $1.5 million and you're single and you're about to go into a nursing home, you may want to contact eharmony.com. Because if you do that, you can end up having the house being protected. So basically, they're the 4 categories that you have. They're the minimum 4 categories you can have in order to qualify for medical assistance long-term care in Pennsylvania. What I'd like to go over is some of the exclusions regarding the transfers, because that's basically the nuts and bolts of elder law. You have to spend down your money. The problem we're talking about in a lot of cases is called the crisis spend down. That means you have a person who's just about to go into a nursing home. There's not too many things that person will be able to spend their money down on in order to qualify for medical assistance long-term care. But there are exceptions. If you have a house, say you have a $400,000 house and you have a $200,000 outstanding mortgage, you can pay off your mortgage. That's a transfer for fair market value, that's okay. And your equity value in your property is now $400,000. You're below the $500,000 home equity threshold that you have to be under. So you can pay off the mortgage. Say you needed a new roof on the house, you could get a new roof. Say if the heating system was about shut, you can get a new heating system put in. As long as the transfers are for fair market value, it's okay. But even though we're the government, we've seen people who wanted to go out and buy jewelry and say they wanted the jewelry for personal use. Well, we've challenged those cases. We have people that bought like $120,000 worth of jewelry and said it was for personal use for the person going in the nursing home. Well, I go into a lot of nursing homes. I don't see people wearing $120,000 worth of jewelry in nursing homes, and if they did bring it in there, it wouldn't be there very long. In a lot of nursing homes, not all of them. So that would be excessive. You can get a car. If your car is a clunker and you have to be replaced, you can get a car. There's really no limit on the amount you can spend on the car. But if you were driving around in a Chevy Nova for years and now you want to get a Lamborghini, we might decide that we may want to challenge something like that. So there are certain kinds of assets you can purchase as long as they're for fair market value. It's the gifting that causes a real problem. If you give your money away, you're going to create a problem for medical assistance long-term care. You can't just gift your money away. It's nice you want to give your money to your kids so you can qualify for MA and not use it for the nursing home, but the taxpayers shouldn't support the generosity you may have for your children. Now, I mentioned if you can give away if you can transfer things within a 5-year period, you're okay. And one of the things we're seeing now because of the Deficit Reduction Act is we're seeing a lot of people transferring into income-only irrevocable trusts. And an income-only irrevocable trust is you take your assets, you put it into a trust, you're able to get the income back from the trust, you're able to have a say on how that trust is going to be invested, but you can't access the principal. You can't access the corpus. Because if you can do that, you can use it to pay for your long-term care. So if you put your money into an income-only irrevocable trust and you can wait out 5 years from going into a nursing home, that's a way you can actually put your money aside, still be able to draw something from it, so you haven't completely divested yourself of that money. Now, the other option is you may want to say, well, my kids are going to take care of me, so I'm just going to give them all the money outright. I don't want to worry about the trust, and if I need any care, they're going to pay for it. Well, if you want to make distributions from the trust for the kids, you can make distributions from the trust. Yeah, sometimes you think your kids are going to take care of you, but I would never recommend that, because the child could have a gambling problem, alcohol problem, drug problem, could get divorced, could get sued, and you can just say goodbye to your money. If you put into an income-only irrevocable trust, you know that money's going to be there. And if you want to parcel it out to the child, you can do that out of the trust. But you still have to wait for 5 years. Because when you transferred that money into the income-only irrevocable trust, that was a transfer within the 5-year look-back period. And if you have to go in for a nursing home within that 5-year period, it's going to create a period of ineligibility for you. And it's for the full amount of the trust. The Deficit Reduction Act also made another major change which kind of sent shockwaves through the elder law bar. It used to be, the old law used to be that if you gave money away, you made a gift, your period of ineligibility would commence on the first day of the month in which you gave the money away. So if you had, I think $125,000 is a figure I can use. Let me see if I jotted down some notes here. $125,000. If you gave away $125,000, you would create a period of, under the old law, you would create a period of ineligibility on the first day of the month in which you made the transfer. Today, a $125,000 gift would create a 1.5-year ineligibility period.